All right, good day. Noon on the West Coast, 3 o'clock on the East Coast. Hope everybody is having a happy Tuesday. And today is workshop number 8 in our series on Arizona family law issues. And I'm not going to read to you the disclaimer, but you can see it on Facebook and probably on Instagram. In a nutshell, I am a lawyer here at Modern Law in Arizona. But I'm not giving you legal advice because I don't know you or your facts or your case. And so none of those attorney-client privileges extend via online at this particular moment. And this is just a presentation for information. And at Modern Law, we do this twice a month to just fill people in on the information that they need. You may know that 80% of people or so end up representing themselves in family court. So this is your life. This is a big deal. It's a legal transaction, and we want you to have as much information as you possibly can while you move forward. This, as I said, is workshop number 8. You can go back and find all of the previous workshops. Are they on our website?
I know for sure on YouTube and on Facebook.
Great. You can find them on YouTube and Facebook, and I think there's some links on our website as well, which is www.mymodernlaw.com. And while much of the information is specific to Arizona, some of it is not. Some of it is super, super practical information. So today we're going to cover child support, but in the past we have covered issues like, how do I find an attorney? What questions should I be asking to interview the attorney? How do I know if I've got the wrong attorney? How much should I pay for services? There's a massive variety and variation in what people spend on their legal matter. And we've taken a very practical approach to help you figure out a cost-benefit analysis of how much you should be willing to spend, or how much you may want to consider spending, and when it's just not worth it. We talk about negotiation strategies. We talk about the procedure. So the first sections in the seminar, the first, I think 1 through 4 or 5, are really all about the Arizona family law procedure. How do you file documents? What are you putting inside your documents? What do you expect when you go to court? What are pretrial conferences? What's the difference? All those things. And now we're in the legal section of the workshop series, which means we're talking about the substantive law, today's child support, which affects so many people, probably the issue that affects more people than any other issue. So today's going to be great. You can ask questions in a number of ways. You can either list comments inside Instagram or inside Facebook, but if you'd like some privacy, and many people do, you can text us, or you can also send a private message through Facebook. And Caitlin, you're monitoring that one, right?
Yes.
Okay, great. So if you send a message to Modern Law through Facebook or Caitlin, yes, she can't see mine, so don't send it to Billy. But if you send it to Caitlin or Modern Law, we'll be able to see your questions. And then, do we also have some questions that came in over the past few weeks? Great. I know we've got a list of those. So here's how this works. We're going to spend about 20 to 30 minutes going over the substantive law. Today it's child support. And then we will dive into any questions that you have. You can ask anything you'd like. And as long as I can give you some information on it, I'll be happy to answer your question. So how does child support work? Child support, in some ways, is part of maybe one of the easiest issues that we come across most of the time. Child support is determined by a calculator, and there's a calculator in every single state. And the calculator takes into account various inputs, both people's income, parenting time, how much time the children are with one or both parents, the age of the child or children, child care costs, and the cost of health insurance for a child. There are other inputs that are also considered, and we'll get into that a little bit more. But child support affects every single case where you have a divorced couple or unmarried parents, and adopted children. Um, and unless there is an agreement, usually to deviate from the guidelines, most of the time, whatever the guidelines state, that's how it works. Now, a lot of people get upset by the guidelines. They don't understand why their friend might be getting $1,200 for 3 kids, and they might be getting $300 for 3 kids, and it can be really frustrating. And other parents just don't want to pay child support. They would prefer to not give their money to their ex. They would prefer to be able to pay for expenses directly related to the children, or buy things directly related to the children. And unfortunately, it just doesn't work that way. The basic premise is to figure out in an intact family what percentage of income is spent on kids. And that includes their share of living expenses, right? So their share of rent or the mortgage or the electrical costs, and that would never be covered by direct expenses to the kiddos. Okay, so as a starting point, the federal guidelines for child support are based on a 2009 report for the Center for Policy Research out of the Pew Institute that really studied actually what people spend. Now, what other people spend might not be anywhere close to what you and your family spend. You may be super, super frugal, and there's no way you spend $1,000 a month on your children, or you may spend a lot more than the guidelines state. And we can talk about deviations, but for the most part, that's the theory. It kind of doesn't matter if you like it or you agree with it. It is what it is. So when does child support end? Child support in Arizona goes through 18, or through when a kid graduates high school. Or if they are 19 and still in high school, the child support would end. If a child is disabled, then child support can go beyond that time. This is interesting because I first started practicing in Oregon, and in Oregon, the child support guidelines go through 21. And I don't remember, I could be getting this wrong. I don't remember if you had to be in college or not. Maybe not. Maybe it just went through 21, which is interesting. But in Arizona, it ends when a child graduates from college and is 21, and is 18, or even if they're still in college, when they turn 19. If you have a disabled child, you're going to want to probably chat with an attorney about that. And this doesn't mean that you and your spouse can't agree to some other arrangement, including, supporting them in college or something like that. So that's something to consider if it's important to you to figure out support until a later age. There's nothing that stops you from doing that. So what counts as income? The first input into the calculator is mom's income and dad's income. And what counts? Basically anything that the tax code thinks is income, the child support calculator thinks is income. So that means wages, commissions, bonuses, severance pay, income from trusts, workers' compensation benefits, annuities, capital gains, spousal maintenance, unemployment insurance benefits, disability insurance benefits, including Social Security disability benefits. So over time can be a little bit tricky. I think I've got a whole slide on that, so I won't. What's excluded? What does not count? If you get child support, let's say for other children, that doesn't go into the calculator. If you receive food stamps or TANF, temporary assistance for needy families, that won't go into your side of the column for income for the guidelines. Social Security SSI money, which is for low income individuals, does not go in. And those are for people who have never worked before or don't make enough money to accumulate benefits. If you do not work, then in Arizona, the court will impute to you income. What that means is they will assume that you are able to work if you're not disabled. If there's not some reason to assume that you can't work, they're going to assume that you are able to work at whatever you could be making. Most often for somebody like a stay-at-home mom or someone who's been home for a long time, it doesn't have to be a stay-at-home mom, they will be imputed full-time work at minimum wage. Now, if you're imputed income and you have young children, also ask the court to consider what those childcare expenses would be. And I believe we covered that a little bit later too. Now, what about overtime or commissions that are overtime based? Sometimes people work a lot of overtime in a certain season, right? Like accountants work a lot between January and April, right? Um, and they might, if they're making overtime, if you work for H&R Block as a receptionist even, but you're working a ton of overtime, then it wouldn't really be fair to impute to you or attribute that income to you all year. Or if you are working for UPS and Christmas season, you're working a ton of extra hours, that can't be expected to continue over the year. So the guidelines state that overtime should not be considered unless it is historically earned and can be anticipated in the future. Now, as you can see, this is kind of a gray area. It's kind of discretionary. Sometimes bonuses are completely discretionary, but you've been historically getting them for the past 3 to 5 years. You can probably expect that that money will be attributed to you, or the court will count on the fact that you're probably going to get that in the future. This is just something you need to be aware of. How about determining how much my ex makes? In each case where child support is an issue, both parties are required to provide an affidavit of financial information. And that is essentially an affidavit means it's a sworn statement. You are swearing to the court that the information in the AFI is true. And the information in there is your budget, how much income you get, the sources of all your income, other sources of income that are contributed to your household, how much you spend on things like health insurance for the kids, food. Did you have a question? No? Okay. And you also have to attach tax returns, W-2s, any 1099s. Most of the time, that document will get you the information you need to determine your ex's income, unless he or she is hiding, rental income or things like that. Everything goes on there. If you feel like they have filed an incorrect or inaccurate or incomplete affidavit of financial information, then there are discovery tools, and there's an entire workshop on discovery tools that you can take a look at in order to determine what might go there, okay? Once a child support order is entered, the court is required to order that the parties exchange that financial information like tax returns and earning statements, usually every 2 years. You're also required sometimes to exchange your residential addresses and the names and addresses of employers to allow for you both to figure out, has there been a significant change in circumstance? Because if there's been a big change, you can always go modify child support. What if you or your ex is self-employed? This can get really tricky. It wouldn't be fair to consider all income earned by a business to be income to a parent. That's not how the IRS looks at it, and that's not how the family court looks at it. But the family court and the IRS do not exactly treat things the same way either. As a business owner, you're allowed to write off a lot of things. Like if you work from home, you can write off your internet, you can write off a portion of your electric bill, you can write off your cell phone. Now, if you worked for someone else, you would have those expenses. So for the family court's purposes, those would not be deductible from your income. So when you have self-employed individuals, this question of what is your income is not clear. It is not as clear as simply going to your tax returns. Usually you can do it a couple ways. You can either add a percentage onto the taxable income, or you can kind of just eyeball it, or you can go through the records really clearly and carefully and kind of nickel and dime to figure out what you think that income should be. What if a parent's unemployed? Well, we kind of touched on this. A court is going to look at whether the underemployment or unemployment is reasonable. A mom with a newborn could be reasonably unemployed. Let's say, the newborn is 2 weeks old. Most of the time, Family Medical Leave Act, most of the time, employers don't expect a mom of a newborn to be working. Mm-hmm. Or a father who moves closer to his children may voluntarily reduce income while seeking new state licensure. Would that be reasonable? It could absolutely be reasonable under the circumstances. And we want parents to be able to be with their children and parent their children, and just because income reduction is a consequence doesn't necessarily mean that he should be imputed or attributed his full earning capacity, or maybe not at the moment. The court needs to weigh the costs and benefits of the parent's choice and the reduction of the child support in light of the best interest of the child. Income that is attributed is usually at least minimum wage for full-time to both parents. Now, other circumstances where you wouldn't necessarily attribute income would be things like a mentally or physically disabled parent, a full-time student, and sometimes that can get really interesting. We had a case where there was a gentleman who was probably 30, somewhere between 35 and 40, and he'd been a full-time student forever. And this mom was upset because she'd been working at restaurants and at the city, supporting essentially her child almost full-time because dad was a student and couldn't figure out what he wanted to do. So if that's the case, you're going to want to present all of those facts to the court and definitely take advantage of those discovery tools so that you can show that this is not reasonable under these circumstances. And then if there are extraordinary emotional or physical needs of a child that require a parent to stay home or care for the child, and this comes up as well. We have one client whose child has needed several heart transplants. His care requires her expert information about his care, and there's no way she could go get a job that would allow her to pay somebody else what they needed to be paid to keep this child alive. So it would not be reasonable to then attribute her income. Or at least that's what we're going to tell the judge because she's the client. But it seems to me that that's a good example. All right. What about new spouses or roommates or boyfriends and girlfriends? It can be so annoying when one party gets remarried to the rich new partner, doesn't work because of it, and you don't get to touch that combined income for child support purposes. But that's how it works. The only people who have a legal obligation to support their children financially are legal parents. These are adoptive or biological legal parents. And since only legal parents have that responsibility, new spouses or roommates, or even if you live with your parents, grandma and grandpa, they don't have an obligation, and therefore their income will not be included. Now, if the expenses of the person are greatly reduced because they don't have normal expenses, right? Let's say they make $40,000, but they live with mom and dad who fund everything. So their $40,000 is just spent on clothing and pedicures each month. You could argue for a deviation, and the judge has the ability to make a deviation for what is in the best interest of the children. What else are you considering in your calculator? Children from other relationships that you are responsible for. So you have 2 children with your first husband, you get married to husband number 2, you guys have 3 children. Your income, whatever your income is, needs to be attributed over those 5 children, not just the 3 that are at issue with the second husband. Any court-ordered child support, so let's say you're paying child support for children that you had from a previous relationship, or if you're paying court-ordered spousal maintenance, that's gone off the top. If you're paying spousal maintenance to your ex, that money is not money that you really have available to spend on your children, so it is not considered. This is interesting. $20,000 in combined income is the maximum amount that the child support calculator really considers. If you want the court to consider income above $20,000, you have the burden of proving that the standard of living for your children would have been higher had your family been intact. Okay, so this is to avoid a massive child support obligation from a NBA star who ends up having a baby after a one night stand. I don't know why, but that, this is the way it is. So that essentially children are not meal tickets to lifetime child support awards. It's interesting, right? So here's the analysis. We had this just happen. We had a couple where dad made a lot of money, millions of dollars, and mom was a stay-at-home mom because why wouldn't she be? There was a lot of money going around here, and they spent a lot of money on their child. They took luxurious vacations, and the child was involved in very expensive extracurricular activities that had her traveling all over the country and had her have coaches. And we got an expert and we showed that this family spent, essentially, about $15,000 a month on this child. And the court in this case did not deviate. Well, no, the court did deviate upward, but the court deviated upward to $1,000 a month for child support for this mom. And we just won an appeal and were able to show that this was not reasonable. This was a 1% of what this gentleman earned. And when you are able to show that an intact family spends X on child or children, then the child support guidelines may not be appropriate. And at that point, you need to ask for an upward deviation. And this is a lot of work. You have to prove your case. And sometimes, even if you prove your case, you have to go appeal it. So it's something to consider, something to look at. And downward deviations work the same way. You can ask for a downward deviation if, let's say, you're paying child support to the mom who lives with her parents, whose parents pay for everything, and so she spends all of her $40,000 of income on fun stuff. You may ask for a downward deviation because of the money that's available to be spent on the child. Who pays for insurance? The court will order someone to cover the child or children for health insurance, or that one party secure access, is what we call it here in Arizona, public assistance for children. And the portion of premiums that are spent on the child for insurance comes out of that parent's obligation on the child support calculation. All right, if both parents can and want to provide insurance, the court can order the custodial parent provide it, or the court could put in the cost for both parents to cover the child. Usually also the court will order a portion of uncovered medical expenses to be paid by each party, and usually that's in proportion to income. So if dad makes 65% of the money and mom makes 35% of the money, then total income, then it wouldn't be unusual for the court to order mom to pay 65 or mom to pay 35% of expenses and dad to pay 65% of expenses. Child care costs also go into the calculator, and child care costs are, this is a discretionary input. So sometimes people spend a lot of money on childcare. Sometimes the court will say you're spending too much money on childcare. For instance, if you've been a stay-at-home mom and then you're going to go to school, and you decide that your children need a private nanny that's paid $45,000 a year, the court may say, no, I'm not going to put that on your side of the child support calculator and have dad pay for all of that, because it wouldn't be reasonable. So it's not reasonable for a parent who's earning $10 an hour to hire a babysitter who costs $10 an hour. And the other thing that's considered is that the parent who pays for child care is entitled to a federal tax credit, sometimes, depending on their income. So that's something that's also factored into the child support calculator. And the other thing I want you to really think about is your childcare costs are not, if your kids are in school, are not usually constant over the year. You've got, camps during spring break or summer or whatnot. So you're going to want to add up your annual costs and then divide it. Any extraordinary expenses, special need costs, older children costs. So if your child needs tutoring, that can also go into the calculator. If your child needs special medication, that can go into the calculator. There are other things that can be considered. And there's an older child adjustment for kids over 12. They get about a 10% bump because apparently they cost more than little ones. Yeah, which is interesting, but they don't have the childcare costs, right? I mean, if you're over 12, you're probably not paying for childcare. So you've got, camps and sports and equipment and yeah. So at this point, you've determined that you've got this overall obligation to support your child. Both parents share this responsibility, and the number is allocated between the parents in proportion to their income. So if mom earns 60% of combined income, she's responsible for 60% of the obligation if the total obligation is, $1,000. Then there's parenting time adjustments. Okay, so we've got, all right, first we know the obligation for the child is, let's say, $1,000. 60% will be mom, 40% will be dad, but who has the children? If there's an equal parenting time, then there won't be any adjustment to that initial analysis. But if mom has all the time or if dad has all the time, then that's going to be adjusted. And if it's somewhere in between, then it's going to be adjusted in proportion to that. There's also a self-support reserve. So if you make very little money, the court is not going to say that you need to spend this all on your child. And I think it's around $1,500 currently that comes off because you're going to need that to support yourself. I don't know who can support themselves on $1,500. Not saying that's right, just saying that's the way it is. It can get sort of tricky if you've got, let's say you guys have 4 kids and 2 of them live with mom most of the time and 2 of them live with dad most of the time. The child support calculator isn't really set up to do that. So you can do several things. You can make competing child support worksheets and offset the amount. You can try to figure out who's going to pay for what things and go from there. This is one of those cases where if you're really concerned, you're going to want to talk to an attorney who's going to need to do some analysis to figure out how this should work.
So would you do the competing child support worksheets because the 2 sets of children's expenses likely to be different, and that's why?
What do you mean?
Well, like if 2 kids are always at mom's and 2 kids are always at dad's, you do the child support worksheet because their individual costs of all the other things might be
right.
What's different.
Exactly. Yeah, and we don't know if the parenting time arrangements are the same. Yeah, it can get a little tricky. Travel expenses. Travel expenses are not factored into the child support obligation. They have to be assigned separately, either in the divorce decree or in the parenting plan. Travel expenses are an issue for, kiddos who live far away from one parent. So they've got flight costs, and that's not factored in. Sometimes the court might use the child support calculator as a guide to say, okay, if mom makes 60%, then she's going to pay 60% of the costs. But the court may also say, nope, dad, you moved, you pay. And this is just a risk. I can't tell you how it's going to go, and I've seen it happen all sorts of ways. Be careful what you say, because sometimes a parent will say, I'm moving, but don't worry, I'll pay for all of the travel costs, and a court may just take you up on that, even if you don't get the other things that you want. So you're saying this because you want a particular parenting plan, you're trying to use it as a negotiation tactic. Well, you may be held to what you say, so it's something to keep in mind. Deviations can occur. If the court determines that in any particular case the guidelines are inappropriate or unjust, the court must determine the best interest of the child, so consider it and make an order. When there's disabled children, we see this. In fact, it's really interesting. I think we researched this and we found that there are more deviations down than up, which is kind of surprising to me. because it feels like there are a lot of cases where a family would spend more on their children than the child support guidelines um, would account for. But I think the overall understanding is that when a couple and a family splits up, things change, and no one is entitled to maintain their exact lifestyle. You are going to need to adjust, and so are your kids. So deviations can be powerful, but they're not set in stone, and so there's something to absolutely consider and think about. What if a child doesn't live with either parent? Sometimes a child might live with grandparents or other third-party caregivers like an aunt or a neighbor, or an ex-spouse, like a step-parent who is very, very close to the child. Now, in that event, the third-party caregivers are entitled to receive child support from the legal parents. So in order to get that support, the third party must seek a child support order from the court by filing a petition for child support and naming both the mom and the dad as the respondents in the action. It doesn't come up too often, but it's certainly an interesting situation. The Office of the Division of Child Support, or DCS, is sometimes involved in cases where a person has collected benefits, or they're trying to enforce a past due child support amount on behalf of one parent. And at that point, your action becomes a 4D matter. That means that the state, the Division of Child Support, will assign an attorney, and they are a party to the case. They will show up at these hearings. They now have jurisdiction over these hearings. And so if that's the case for you, then you will have your family court judge will not decide that issue. The family court judge may enter an order for parenting time or a modification of parenting time, but they will refer the child support portion to a 4D hearing. Usually those hearings start with a mediation or a conference, which is sort of like a mediation, to see what can be worked out. And then the Attorney General's office needs to sign off along with the parents. You can always modify child support, and there's a number of ways to do it. You can modify child support when there's a change of circumstance that would cause a change of the child support obligation of 15% or more, okay? So just because you make a little extra money doesn't mean you necessarily qualify for a change in child support. But if that child's going to, if the change is going to be more than 15%, then you will. For instance, we talked about a child support obligation of $1,000. If you have lost your job and you've been demoted and you make a lot less, and your ex makes a lot more, and the new child support obligation would be $1,300, then you would qualify to ask for a modification. And you can ask for a simplified procedure if everybody agrees on the terms. You know what the numbers are. You just need the judge to enter in the new order. But if there's a question on what those numbers are, if we're fighting over what's mom's income or dad's income, then you do a more standard process for modification that allows for discovery and responses and that sort of thing.
Are you required, if your income goes up, to have to do that, or is just the other party responsible for requesting that the child support be changed?
You are not required proactively to ask for a modification if your income goes up. You are required to exchange information. That doesn't always happen.
Just curious.
Yeah, no, you have no obligation to say, hey, I got a raise, I'm going to go increase my child support. Don't have to do it. Tax exemptions. The federal and state tax exemptions for minor children are assigned in the child support order according to income. This makes people very angry. No problem. This makes people very angry. Sometimes, mom has the kids 80% of the time. Dad makes 80% of the money, and dad is therefore ordered to take 80% of the tax exemptions. And mom just gets irritated. She's like, why should he get to take the exemptions if I'm paying for them and taking care of them? I get it. I do. And the IRS says blah, blah, blah. Yeah, this is a problem, is what I can tell you. The IRS has its rules. Every single state has their own rules. They don't always line up. You need to follow the court order. And the reason that the tax exemptions are factored into the child support calculation is because your child support that you're receiving, mom who has the kids 80% of the time and dad who makes 80% of the income, should be enough to cover the fact that dad is taking the exemptions, should account for the fact that he's paying the child support that he's paying. If dad is behind on his child support, or if any parent is behind on their child support obligation, they are not allowed to take the tax exemption. So I had one client who was technically behind, like technically behind, because I think he was behind like a week in paying his child support. And mom took the exemptions, and she was allowed to do it.
Dang.
Yeah, yeah, yeah.
I mean, that's an awesome thing for people who are really avoiding it, but
Right. But in that particular circumstance,
it's a little bit.
he was upset.
Mhm.
He was accountant though, so like, what can you say? And I think some of that might have to do with the clearinghouse and their timing of the payment. Not good. Something to watch if you've got the type of ex-spouse who will jump on the fact that you're behind. If there is unpaid child support, it does not go away. It accrues and it earns interest. And we had a client not that long ago who owed something like, I think, $75,000 in child support. And he swore up and down that he had never been made aware that this child support order existed and that he paid support directly to the mom, and it's so unfair, and it does not matter. Nothing you say is likely to make a child support order go away. It never expires. You can't bankrupt out of it. You can try to negotiate directly with the other parent for, let's say, a lump sum payoff. So you could say, I can come up with $25,000 now and pay $1,500 a month or whatever. If you forgive the rest of these arrears, that's allowed, as long as the state doesn't have an interest. Now, if it's a 4D hearing where the state does have an interest, then that might not work because the state may not sign off on it. If one party is behind, they can be put in jail. They can lose their driver's license. It's something that is taken pretty darn seriously. Like, yeah, arrest warrants can be issued. It's not something you really want to mess around with. And if you are in arrears, the most important thing is to come up with a plan and start making payments. If you come up with a plan, the court will usually sign off on it if it's fair and substantial enough. They'll sign off on the plan, and you will be allowed to make those payments while interest accrues, and you won't be taken to jail. If you are taken to jail, they will let you out so you can work, so you can pay your child support, and then you come back at night. And that is all for today. On that light note, we'll just wrap it up there. Next time, so we do these twice a month on the first and third Tuesdays of the month. They are live on Facebook, and then the recordings are on Facebook and Instagram as well. Oh my goodness, we have the wrong website address on here. It's not modernlaw.com. It is mymodernlaw.com. We do right here. Oh yeah, it's just in the notes that I see. Good to go.
Okay. I was like, that's not what I see. But
Good. I was just looking at the notes. All right, so do we have other questions?
Yeah, we have a few questions. I'm
Okay.
just going to swap this so that people can see you as opposed to watching an empty screen. And you could take it off of the share screen mode if you want. So that they can
Okay. Let's see.
So it's just one.
Off the share screen mode.
Yeah,
Did I do that?
stop
Good
share.
to go? Okay, great. Fabulous. Thanks for fixing that.
You're so welcome.
All right, what are our questions today?
Let's start with the first question. It is, do I have to file for divorce to get child support?
Yes, beautiful question. If you are married, the court has no jurisdiction over how you run your house. This comes up in a lot of ways. Sometimes one parent will say, I'm leaving and I'm taking the kids. And the one parent wants to prevent the other parent from leaving and taking the kids. If there's no pending divorce petition, the court doesn't have any jurisdiction to tell either of you how to parent. You have a duty to support that's a legal duty, and so I believe it's technically a crime to abandon and not pay, but in reality, with the way that our system works, you're expected to file for divorce and ask for child support. And sometimes you have a child support order and people living in the same house. That gets interesting because most of the time that means you're both supporting the child, and the court will sometimes forgive that type of arrearage. So if you can show I supported this person, we lived together, then that's the type of arrears that might be forgiven.
What about if they just file for a separation?
Yeah, you can file for a legal separation, and the court will then have jurisdiction over your issues, and you will be able to get child support.
That's got to go to different sections.
No problem.
I pay child support, and my girlfriend is still always asking me to pay for all the things that come up for our son. That is why I pay child support. Shouldn't she need to cover fees for field trips and registrations for sports? I feel like my child support isn't going to support my child, and she's just using the money for herself.
Yeah, that comes up a lot. So field trips and clothing are the types of items that are considered in child support. This gets a little bit tricky because does it mean that if all the field trips happen to fall on mom's days that mom always pays for the field trips? Or does it mean that if the money is due for the field trips on dad's days, but the kid goes on field trips on mom's days, who pays for it?
Jeez, that's complicated.
It's complicated. The best thing you can try to do here is communicate. You're not obligated to pay for the field trip, but of course you want your child to be able to go. And so you want to be able to figure out a way with mom to make sure that your child has what he or she needs. And I can understand how frustrating it is. Sometimes parents, you're raising your child the way you want to. The two of you are not doing it together anymore. Shoes may be really important to you. You may always want your child to have, clean, sturdy, high quality shoes. The other parent may not care. I mean, it's just not a priority to them. And
Right.
I'm not saying that makes them a bad parent or neglectful. Maybe it does, maybe it doesn't. I'm not saying that. What I am saying is you guys might have different priorities. Or clothing. It could be that one parent wants the child to look super good, put together, ironed clothes. The other parent's like, pick out what you want, and that could lead to a lot of frustration and resentment. This goes to co-parenting. Co-parenting with somebody that you don't necessarily like in houses that you don't live in can be hard. And I think child support in this sort of question is really an extension of that issue.
Okay. This one's a little broad.
Okay.
But I think that, especially in light of your comment that even if you don't maybe know that you're accruing child support, it just never goes away. I feel like maybe this might deserve a little bit more. So it's how can I get child support if I can't find my child's father?
Okay, so you need to get a child support order first and foremost. And you get an order, like we talked about. First, there has to be an open case. An open case is either a divorce or a petition to establish paternity, child custody, and parenting time. So if you're an unmarried parent, there's no order in place. If you're a married parent, there's no order in place. First, you have to get an order. In order to get an order, you have to serve the other party. You have to put them on notice. And I believe we talked about this. I'm not sure. Do you remember which workshop we talked about this?
I feel like it was 3 or 4, but that's like
Yeah.
a total.
I'm not going to make you go like look in there. So finding someone to serve them can be very challenging. If you don't know where they are, then you are able to technically serve them via publication. It's a long road. Basically, you have to take a lot of steps to make sure that you've demonstrated to the court that you've tried to give them official notice, that you cannot, and that therefore you're going to put it in the newspaper, because everybody reads the newspaper and the sections that have the legal publications on them. So that's the law. It would be better if they posted on Facebook, but that's not the law. So you can post it into the newspaper, and then you'll have a child support order eventually. That order will accrue, it will accrue interest, and it will never go away. So that when you do find the father, you can try to attach your judgment. Unpaid child support becomes a judgment, and you can attach it to any of his assets, retirement accounts, anything that he accrues. And then utilize those enforcement mechanisms and arrest warrants and loss of driver's license to try to explain that the duty to support your children financially is probably considered one of the most paramount duties that you have as a parent.
Good. I have another question, not fully related to this topic, but came in through the screen here. If the mother's health is bad and forced to live with her parents, what would be the chances that the father could get custody?
Custody is two things: physical custody and legal custody. All right. So in Arizona, legal custody is called sole legal decision making. And if you have two good parents, you almost always have joint legal decision making, unless there's such high conflict that the court must choose someone. So if mom is disabled, let's say mentally, and unable to make decisions, then I think it is pretty likely that dad will end up with sole legal decision making. Now let's go to the other part of custody, which is parenting time. Where do the children spend their time? You, in Arizona, will not be penalized for living with your parents. The judge is looking at what's in the best interest of the children. One of those things that they're looking at is the relationship that the child has with other people in the household: brothers, sisters, new boyfriends and girlfriends, and step parents and step siblings, and living with grandma and grandpa who are helping out because mom's physically disabled is almost never a bad thing, as long as the environment is good. And I mean, we have to look at the facts of the case, but if you can show that you're able to take care of your child, even if it's with help, if you're able to take care of your child in Arizona, it would be unlikely that a judge would then yank your child from you. I even had a case not so long ago where mom is terminally ill, unable to communicate, unable to talk, bedridden. And it was still important to the judge that that child have time with his mom. So
it's pretty complicated.
It's complicated. It's complicated. It's an individual scenario. If we go to the mom who was terminally ill, the one that I was just talking about, usually in a case like that, it wouldn't be reasonable for her to have equal parenting time, because that equal parenting time would really be with the grandparents, not with mom.
Right.
But if mom is, recovering from knee surgery, it's completely different.
Yeah.
If mom has cancer and is undergoing cancer treatment for 3 years and she's, struggling, she's still parenting. It's unlikely that we'd have to look, at the actual situation. Is mom able to parent? So I hope that helps.
Yeah.
Good to go.
I don't see a lot of other questions coming in. I was just checking the different.
All right. So if you find that you have questions, you can text them to us at our office line, which is 480-649-2905. You can send them in via messenger. You can email them in. You can call the office and say, I have this question that I really want to be addressed at the next seminar. You are allowed, and we encourage people to come in live. Oh, we do have one more? Okay, well.
You can keep going until it's not like
All right. So you can come in live and meet with us. When you do come in live, we usually give you a copy of Decode Your Divorce, which is a handbook on Arizona divorce that I wrote. And we have all sorts of goodies we like to share. So come by, don't be strangers. We like to interact with you, even if you're not looking for modern law to represent you. Did they change their mind?
I just did the wrong thing.
Oh, no problem.
Maybe you just email it and we can try
Okay,
to cover
no
it.
problem. Maybe we got like 3 dots that were like, I'm sending, and then they didn't.
I don't know that Instagram does that.
Oh.
So here it is. If the father gets ill and can't work and can't pay his child support, what can he do would be my.
This is a fantastic question. What happens if you cannot pay the child support obligation? You've been ordered to pay.
Right.
Something happens, you can't pay it. What do? You must modify. Because until you go file to modify, that obligation will just keep accruing, even if it's impossible. So the person that I was speaking about earlier who had the $75,000 arrears,
right,
his child support obligation was something like $1,600. It was based on him making money he never made. It was an incorrect order, but an order is an order, and the court does not go back and reverse modify the order. So if you get ill, if you lose your job, if you're unable to make the payments you're ordered to make, please, please, please file a modification sooner rather than later.
And as long as there's a deviation of 15%, you said?
It's not a deviation. As long as there's a change in the obligation that would be 15% or more, it's assumed that there's change in circumstances enough, and you can absolutely modify. Yeah. All right. Well, thank you guys so much, and we'll talk to you, and we'll see you next time. Bye.